Hi, and welcome to Meet the Professors. My name is DEANA Pollard-Sachs, and I'm a professor of law at Texas Southern University. My guest today is Fred Galvez, who's also a professor at law at the Pacific McGeorge School of Law in Sacramento. And today we're going to be talking about harassment and bullying. So Fred, I know that you're familiar with the case called Snyder versus Phelps. And let's start talking about that case, because that is a case that concerns me a lot. And what bothered me a lot about the opinion is that we have this bullying crisis in our society, and I think the court's opinion may have created a constitutional norm that may actually encourage bullying. What did you think about the opinion?
Well, it was troubling to me too. I'm a big defender of the First Amendment, and I understand the First Amendment, and you have the right to, engage in your protected speech. But this was done in such a mean-spirited way, and it was, recall the Westboro Baptist Church, and they have a lot of political and religious beliefs, and they are the ones that go around, they say God hates fags. And
their website is godhatesfags.com.
Right.
And just to be clear, to get the facts a little bit, Matthew Snyder was killed in the line of duty in Iraq, and his dad spoke to the press about them having a funeral service for him in their hometown, and the Westboro Baptist Church found out about it and flew all the way to Kansas to picket the funeral. It's something they've been doing for a while, getting a lot of free press coverage for their views, which is that God is punishing America for tolerating homosexuality, and that God is allowing our soldiers to be killed overseas because we Americans accept homosexuality, or that a lot of us do anyway.
Yeah, and there's nothing wrong. I mean, you may hate that speech. The Ku Klux Klan says certain racist things. I defend their right to say it, even though I hate the message that they are saying. I would similarly say the same thing about Westboro, but they have a right to say it. That's not so much the problem. You know, they could have chosen anywhere to have their protest. They could have gone to any military base, the Supreme Court, Congress, anything like that, but they specifically sought out a grieving family and a private grieving family. They were not public figures of the family of Matthew Snyder, and they chose the occasion of the funeral. And it's this publicity-seeking strategy that they have. If we can show the grief of an individual and that we're exploiting that grief, that becomes a press event. The press is sort of saying, oh, that's interesting information.
And they did more than that. They did show up and they picketed the funeral, and there was a regulation requiring them to be 1,000 feet from the actual proceedings, and they did adhere to that. I mean, the Westboro Baptist Church is mostly family members. Of around 70 members, 50 of them are related by blood. So the people who are related by blood have law degrees, at least some of them do. And so they know how to kind of walk a fine line. So they did adhere to the local ordinance about staying back 1,000 feet from the actual funeral procession. But what bothers me is they went further and created an online epic about the family and said terrible, defamatory things that unfortunately were not actionable, because they went and dug into Matthew Snyder's divorce file and found out that his ex-wife had alleged adultery, which may or may not have been true, but because it was in the filing, and because the members of the Westboro Baptist Church know that once something's in a court filing, it generally is immune from liability for defamation, and they splattered that all over the internet about a dead soldier. And then they went further and started accusing his parents, Albert Snyder, who brought the case, his father, of being a terrible parent, of rearing their child basically against God's values, and how they rose him up for the devil, and I mean, really awful things.
Well, and that's the problem too. What does that have to do with their general political view about the United States, about homosexuality, about the Catholic Church? They had big problems with the Catholic Church, and they chose the fact that he was Catholic too, to individually go after him. And then, the court said, well, they adhered to the ordinance. They were on a public sidewalk where they had a right to be. And it's almost like the court is saying, if you engage in the intentional infliction of emotional distress, as long as you do it from a public sidewalk, it's okay. And that shouldn't be the law. We shouldn't mix protected First Amendment speech with unprotected First Amendment speech and say, since it's all together, let's just throw it in there and say it's all protected.
Right.
We make
Right.
distinctions all the time between protected and unprotected speech.
Yeah, but sidewalk picketing is a sort of historical American means of disseminating free speech, just like standing on a soapbox back in the day, you know, that in New York they'd stand on the corner of the soapbox and start spouting out whatever they felt. And I think that's traditionally protected speech. And I think there clearly was political messages involved in the speech, but two things concern me. One is anyone can decide to go after someone they don't like and mix political messages with, you know, hate speech and with really invasive, I mean, speech that would be probably actionable under invasion of privacy if it weren't for the fact it was mixed with political speech. They mix it up to protect what really is intentional, you know, emotionally distressing speech directed at an individual. And the other thing that bothers me is that by doing the online epic, they really went way farther than they should have. And the court, despite asking a lot of questions, you know, at the Supreme Court level, at the hearing, they asked a lot of questions about, you know, to Sean Summers, the attorney for Mr. Snyder, you know, was the epic different or the same as a sidewalk picketing? And despite asking all these questions during the hearing, in the final opinion, they chose not to discuss the epic at all. And the epic to me was clearly the better case for invasion of privacy and intentional infliction of emotional distress because it was so clearly unnecessary to their political speech. And it also was targeting an individual grieving family for cruel, I mean, statements. Imagine if your son had just died and someone said, well, you as a parent raised him for the devil. I mean, that's about as bad as it gets. And the signs were pretty ugly too. You know, God hates fags, fag troops, thank God for dead soldiers. And that's the sign that Albert Snyder testified really deeply disturbed him, the thank God for dead soldiers. He says he can't even think about his son without seeing the image of that sign in his mind. But what bothers me is that, you know, the court kind of chickens out and dealing with the difficult issue about the online epic, because to me that was clearly a better case. And I have to say, they had a sort of procedural out. There was what I would call a pleading error in the Supreme Court brief where the question presented did not discuss the epic online. And so in the final analysis, the Supreme Court decided to, you know, use that fact and say, well, we can't discuss that, or we're not going to discuss that because it wasn't directly presented to us.
That, you know, it's the weakest argument that the court would have in trying to represent that epic as still being part of the general political public kind of speech. And so instead of taking that head on or trying to deal with that argument, you could almost imagine him saying, oh, we could just ignore this because it hurts us, but the way we ignore it is based on a procedural ground. It wasn't presented in the right way, and so now we get to ignore that issue. But that doesn't ignore, or that doesn't take into account the fact that this still had private a private tort involved. And they, like you said, they just mix it up with the public, with the First Amendment, and just kind of whitewash all the negative tort involved with the First Amendment. You know, there needs to be a balance between the First Amendment and the private torts. And I would be arguing the other way if they said, well, forget the First Amendment, this is a private tort, so forget the political speech, it was mixed with the private defamation. I would say, well, now that's going too far for the tort. But by the same token, I think the court goes too far in completely sort of ignoring the important tort aspect of this and just focusing on the First Amendment.
I mean, one of the things that bothered me so much about that case is that no one seemed to consider Mr. Snyder's First Amendment rights. I mean, he's disseminating information through the press about his son's funeral so that their friends and family and just concerned people can come and pay their respects to Matthew Snyder, a fallen soldier. And by ruling the way the court did, they've really squelched the speech of grieving parents, because if it were me and my son was a fallen soldier, I wouldn't tell anyone, because I wouldn't want these hateful people from the Westboro Baptist Church to show up at my son's funeral. And so that was something that wasn't considered. And something I argued in my Yale article was that, what about him? What about the rest of us? And what about the fact that we have the worst bullying and harassment culture ever? I mean, bullying is now 4 times more prevalent in the workplace than workplace discrimination. It's on the rise. Teen suicide is on the rise. Cyberbullying is a huge problem. And I think by ruling the way the court did, the message was sort of sent out that, you know, anything goes basically you have to, fend for yourself in this life. And I don't think that's the right message in this social
Yeah, well,
context.
what it does, I mean, you can even imagine little kids on the playground saying horrible things to one another. And if they read a case like this, they could say, hey, I have a First Amendment right to call you whatever horrible name that is, as long as I can intersperse some public, political, First Amendment kind of reason for doing that. You can have a neighbor that you don't like and then say horrible things about him or her. And then as long as you have some public political speech that you can attach to it, you can cloak all of what would otherwise be defamatory speech.
Or invasive speech,
Yeah.
or emotionally distressing speech. It's intentionally perpetrated. Well, less than 30 days after the case was handed down, another case was filed because a paramedic who was the first to arrive at the scene of a very ugly, gruesome murder had taken photos of this young girl's slaughtered body and put them on Facebook. And her parents sued, and I'll bet he probably assumed, I don't know if he read Snyder versus Phelps or not, but the message is out there. People tend to find out about rulings. I mean, it's on the news for sure, but that's the kind of behavior we want to stop, not encourage, especially with the teen suicide rate. Kids as young as 11 years old hanging themselves from being bullied at school. The kid I'm thinking about in particular was bullied about being gay. His mom said, we don't even know if he was gay. He was 11. He may not have even known yet. And yet we're losing, and he was a straight A student, by the way, and we're losing these fabulous young people because other mean kids are just completely unrestrained in their hate.
Or even if it isn't that, insidious and negative and evil, what if the paramedic were to say, I want to put those pictures of her maimed body to let people know that they shouldn't drink and drive, or not even if that were the case, but they might say, I'm going to justify it that way. That way I can put on these kind of photographs, get my jollies or whatever it is off of that. But if I can just
couch
run
it
under
in terms of political speech.
the banner of the First Amendment, then all of a sudden I'm patriotic for bringing this point up, and it's of public concern, yet I get to bring that information or that kind of horrible photograph and put it out there.
And I realize that the court is the final arbiter of the Constitution, the First Amendment, but the jury gave Mr. Snyder $11 million. And that's a statement. Juries don't just give money away, regardless of tort reform propaganda. That is just not true. And then at the end of the day, when it was reversed, he owed over $16,000 in attorney's fees and costs. I mean, this is a man who really didn't have the money, and so not only did he not get a remedy, but the way our judicial system works, he ended up with a huge bill just by trying to vindicate his family's privacy rights.
Gives new meaning to adding insult to injury.
Absolutely.
When you think about what happened in that case. The dissents were very powerful. Alito and Breyer. In fact, one of the things that Breyer said, he gave an example, and he said, if A chooses to assault B, and because of the assault and it being a horrible thing that might draw public attention, and then engages in protected speech, that protected speech should be what is protected, the public concern. But the assault, which is still very private, even though it took place in the context of public speech, we still wouldn't say, well, the assault is okay now, because as you were assaulting this person, you were talking about some public political issue.
Right, but there's a clear First Amendment answer to that, and that is that hitting someone is not speech. I mean, everything that Phelps did was speech, writing the epic online, picketing, the signs. So, I mean, not that I'm not agreeing with you or Breyer, but what I'm saying is that the answer would be that everything that the Phelps did was speech, not hitting, not assaulting, but actual speech. But speech is actionable in these kinds of situations.
I think his point was, though, a tort.
Right.
Now, we could see a tort, we see a tort more clearly when it's a physical assault.
Right.
But remember, these intentional infliction of emotional distress and the invasion of privacy, these are all still torts. And so I think he was trying to say torts are still torts.
Right.
And when we see this in a more stark example of a physical kind of tort, we see, oh, the First Amendment shouldn't trump the tort.
Right, and that's the
Yeah.
problem. It's a trump card, because what I argued in my piece was that the court has been constitutionalizing torts for years, starting in 1964 with New York Times versus Sullivan, the Martin Luther King case, and they constitutionalized the tort of defamation for public figures by raising the proof elements. And I argued in my piece, they could do that here too. They can say, yes, there's political speech involved, and yes, that affects tort liability, but it doesn't trump tort liability. You basically have to balance the interests involved, and perhaps Mr. Snyder would have higher elements of proof to sustain his claim, but it doesn't mean you just throw it out altogether. And it really concerns me too, because the cost of litigation is so outrageous that people can hardly find a lawyer when they have a really good case. And when you get a case like this, I mean, Sean Summers spent years working on this case, and the final analysis didn't get a dime out of it. And do you think he's going to take another case, even a good case? Because these cases are tough cases. And so not only do we have this bad constitutional norm as a result of this decision by the Supreme Court, but it's probably also going to have all sorts of secondary effects, such as making trial lawyers not want to take cases.
Well, you bring up the important point. What's happening with litigation already? It's already so expensive, and people will say, well, this is really something for the rich or people that have a lot of resources to engage our system. And when they engage our system, they can go and get justice. One of our hallmarks are, hey, you get your day in court, you get due process, opportunity to be to be heard. The funny thing about it, I guess in parentheses should be, if you can pay for a lawyer, to pay for how expensive it is, and if you have the time to take off of work and do it. So although we say things like for every wrong there should be a remedy, and we should get our day in court and justice and God bless America, and we all believe in that, especially us as law professors, pushing out that ideal. The reality is many people, not just poor people, but middle class people, even upper middle class people, still can't afford how much money it takes. And it's a big gamble, because what you're saying is, we're not going to put you in the position you otherwise were in were it not for the wrong of the defendant. But even if you win, your attorney's fees and the cost may eat up half or all of it.
Or exceed. I mean, the cost, we were talking before about, my husband's a trial lawyer, and he knows a lot about the procedures and what it takes to get to trial. And he said, even in a case where there's really, no insurance companies involved, because they are known sometimes to oppress plaintiffs' lawyers filing motion after motion. I mean, they're bottomless pits of money, especially in the med-mal context. But he says, getting just any simple case of trial, you're looking at least $25,000 to $50,000 if you're paying the lawyer. Otherwise, the lawyer's eating his time and doing it on a contingency fee basis, but that's time he could have made $25,000 or $50,000 doing something else. So when you add to this sort of assault on private rights that I feel is the result of the Snyder versus Phelps opinion, the fact that tort reform and the kinds of propaganda that have been disseminated to the public, making the public think that, for example, trial lawyers are the problem with the world, and the press coverage on the McDonald's case was just outrageous. I mean, this is a lady who was badly injured, and she spilled the hot coffee on herself.
And you'd never think that she was badly injured to hear about it. It's like, oh, she spilled a little coffee on
Well,
her
I've
and she
seen the
got
photographs.
millions. She had third-degree burns.
Oh, she was all the way to the bone. And the thing that the public doesn't know is her lawyer was at first just asking for her medical bills to be paid. She didn't ask for pain and suffering. She didn't ask for punitive damages. She just couldn't pay the hospital bills, and that's all she wanted. It was like maybe $20,000 or $30,000 or something like that. And McDonald's took the hard line position of, we aren't giving you a dime. And so they had to go to trial. And when the jury found out how she was treated, that's why she got the millions and millions of punitive damages.
The public relations war, you'd think, who is the greedy person here? Is the greedy person McDonald's? Because the whole reason McDonald's would heat up the coffee that hot was to save money, because you could get more flavor when it's hot. They had received a lot of complaints.
700 complaints were on file with McDonald's about being burnt.
Yeah.
Badly burnt by their coffee being so hot.
And they don't want to pay her. But instead of McDonald's being seen as greedy, they just flipped it and made her seem greedy. And since when should you be seen as greedy when you've been wronged and you're just trying to put yourself in the position you otherwise would have been in were it not for that wrong?
Well, again, tort reform propaganda. I mean, if you look at the companies who are funding the billboards, the advertisements, all of the propaganda that is trying to make trial lawyers look like greedy pigs who are just out to make a fast buck, and plaintiffs in cases, you know, just greedy gold diggers trying to make money off a big company like McDonald's. People are already sort of having a mindset consistent with that. And we talked in another show with Ed Donnerstein about the fact that people are programmed through propaganda. And so you have a public that is largely very confused or unaware of the true facts, and their knee-jerk reaction is, you know, I remember one guy in Starbucks I was in one day, and he said, he yelled out in a very obnoxious fashion, "Hey everybody, coffee is hot. I mean, duh, coffee is hot." And I almost rode into Starbucks and said something, but I thought, you know what, it was so ridiculous, I didn't do anything about it. But my point is that, you know, tort reform has really made people have this mindset that, you know, plaintiffs are bad people. And the truth is, there is so much medical malpractice, for example, going on. And when tort reform got real heated up and all this propaganda was disseminated about how, you know, doctors are being wrongfully sued, Harvard conducted a study in 2006. And the Harvard conclusion was that the vast majority of medical malpractice claims are valid and involve serious harms and negligence. I mean, clear negligence on the part of the doctors. And yet those claims are being dismissed without remedies because the insurance companies are beating down the plaintiffs' lawyers and the plaintiffs where they cannot sustain the lawsuits.
Well, I'll give you a perfect example. This talk show that we're doing right now and trying to bring the truth about the McDonald's, about the tort reform, what they would do is flip that around and call us hypocritical, because in a sense we're saying that it's unfair to paint the plaintiffs as greedy, but they'll say, well, you're doing the exact same thing. You're painting the medical groups and the insurance companies and the big corporations as greedy. So it's very difficult when we're saying, but wait, we're trying to show the legitimate studies. We're not doing propaganda. We're bringing out the legitimate study that was done that's being ignored.
Well, here's my response to the medical community. If you want to limit med-mal actions, control your doctors, control your dentists. Because it turns out the same doctors and the same dentists are sued over and over again. And if the state boards would take away their licenses to practice medicine, they wouldn't have the problem. But they're not self-governing. They're doing everything in their power to protect. For example, the dental board in Texas will not give any civilian any information about any dental complaints. So if a dentist has 50 complaints of fraud filed against him by 50 different people who don't know each other, none of those people, if they were to file a lawsuit, would get any information on any of those other people, so they wouldn't be able to bring them in, say, a deceptive Trade Practices Act claim, which they're entitled to do, but they can't get their hands on the information. And by the way, there's a term for it. I've talked to a bunch of plaintiffs' lawyers about this, and they said the term is conspiracy of silence. And what that means is that dentists and some doctors in general will refuse to testify against another dentist or doctor because by doing so, the plaintiff can't win her case. The plaintiffs have to bring in an expert to explain to the jury what the medical professional did wrong, because we as average people don't know medicine. And so if you can't get an expert on the plaintiff's side, you lose your case. And if everyone sticks together and no dentist is willing to testify against another dentist, then all dental malpractice cases go by the wayside. So they've got it down, but it's so grossly immoral what they've been known
that's
to do.
another brings up another issue that happens in some big cases where it comes to experts. There will be a very big firm has a lot of resources, and they'll go out and they'll hire all of the experts in the area, knowing that they're not even going to use anyone, but they become consultants. And when they do that, it then becomes a conflict of interest.
It's
for
called
that expert.
conflicting them out. And I actually had a friend recently tell me that he may be going through a divorce, but he said, don't worry, I've conflicted out all the good divorce attorneys in town. I'm like, I said, how did you know about that term? He's a doctor. And he said, oh, you know, I have a good lawyer. So he went to each lawyer in town that was one of the best divorce lawyers and discussed the case with them, which means that divorce lawyer can't take the wife's side of the case because it's now a conflict of interest. He's received confidential attorney-client privilege information from my friend who did this.
And that happens, of course, with advocates. Lawyers are advocates. Expert witnesses are supposed to be witnesses. They're not supposed to be advocates. But we, with our system, we essentially make them advocates. We make them our hired guns, in a sense. We say that about lawyers, but expert witnesses become that, although we try to say that they are a witness.
Yeah, but we as lawyers testify against each other all the time.
Lawyers will sometimes tell them, what goes around comes around, and so they'll say, if you testify against a fellow doctor or dentist or anyone, then be prepared, someone will do that against you. And so they think, I don't want to do this. If I were on the other side, I wouldn't want some fellow doctor or dentist. And so they get scared. Now, there are ethical ones that'll say, hey, just like there are ethical attorneys that'll say, even though you're part of my profession, I still care about the public and what is going on. But there's really no way to ferret this out where people will protect one another or conflict out that way.
Yeah. Well, it seems to me that there needs to be some changes made, and it's so difficult because litigation is so expensive.
Yeah.
And, you know, a lot of the problem too is the judges. I mean, one of the things that we can do as lawyers and parties in lawsuits is get the attorneys sanctioned for misconduct, and their judges just by and large will not issue sanctions.
Yeah.
Let me give you another example. We had a case where medical records were obtained under the table by a lawyer. And that's a federal crime under HIPAA. It's a 10-year prison sentence. It's very serious. And when the lawyer realized he got caught, he immediately signed an affidavit to the court saying, I never got the records, no one in my firm ever got the records, no, I have no idea what they're talking about. Well, this lawyer apparently didn't realize that there was a receipt with his name on it describing the records he had gotten copies of. It comes down to the judges. I mean, when judges won't issue sanctions, when judges won't control lawyers, they're the final decision maker. And if they're not willing to sign orders, or they're willing to sign inappropriate orders or unfair orders, that needs to be disseminated, because we vote for judges. Yeah. I mean, they're appointed sometimes, but when they come up for re-election, they're voted in. In Texas, they're voted in from the get-go. So,
well, those are the state judges. Federal judges, of course,
are appointed by the president.
But still, you make a good point about the fact that these judges aren't issuing sanctions. But some of them would say, well, it's not because we don't want justice to be done. Some of it was actually a reaction to people filing so many Rule 11 motions for sanction. Rule 11 is a way to go after sanctions if a lawyer signs a pleading that they shouldn't otherwise
issue
decide.
sanctions against the lawyer asking for sanctions if it's a frivolous request.
But the thing is that it's gotten so bad because judges have gotten so skittish about issuing sanctions that now it's like they've raised the bar for what you can get away with.
Yeah, the reason they did that is because there was so much litigation and everyone would file a Rule 11 motion or a motion for sanctions, and so they thought they were getting too many motions for sanctions. And every time someone would lose, you'd get a sanction. And so the court, and the federal courts at least, said, well, maybe we should, instead of making these mandatory, we should make it where you may issue sanctions. But I think the judges went too far, and they were saying, oh, these Rule 11 motions, many of them aren't legitimate. And so now the pendulum swung the other way, only too far. Well, they'll say, well, we're not going to issue the sanctions.
The rational actor assumption would say that when there are no consequences, people are going to be aware of that and they're going to do whatever they want, and then others will see that they got away with it, so then they're going to do it. So something's got to change. So let's talk about know what possible things can we do to start reversing this horrible trend. Our judiciary is a disaster. People can't get a remedy. They can't afford to go to court. The judges aren't doing their jobs, and yet they're being retained because the public doesn't know who to vote out of office. So what are some of the things that people can do? I mean, for example, for bullying, it's gotten so out of control, and the research shows that bystanders tend to just look the other way because they don't want to get involved. They don't really know why it's happening, but they see abusive conduct and they just want to get out of there.
Yeah.
And I think that that's a big mistake. I think that people should stop and say, hey, why are you being so mean to her? Why did you just say that? But see, they don't do it because they don't want to be the next target. That's what the research also indicates.
Well, that's the thing. You point out what should they do. Now, ironically, one of the things they should do are file lawsuits to try and do that. And then,
expensive.
And you're in this catch-22, because if you're saying, oh, the remedy is to file a lawsuit, I thought you just were railing on the whole legal system and how expensive it is, and we are. So part of it is making the legal system more responsive, again, for middle-class people, upper middle-class people that can afford it, and try to take away some of the abuse that happens. For instance, in discovery, where there is a factual investigation of the case. what you could do is if you drag your feet through a discovery, or you produce too much information or not enough information, or you fight over how they ask for the information, you essentially send a message to the other side. I have more money, more time, more attorneys than you do. I'm going to outspend you, and I'm going to outlast you.
And this is why so many medical malpractice cases are being dismissed without a remedy, because the insurance companies are beating down the plaintiffs. And that's just, it's so offensive, because what that does is tell doctors and dentists, you can go ahead and commit malpractice. You can make a greedy choice to put braces on someone who is clearly not medically in a position to have braces put on her teeth, and you can expect to get away with it. In this particular case, at one point I spoke to the dentist, and he said to me, if a lawsuit's filed, it'll just be dismissed anyway. And he knew that no matter what happens, he's probably not going to see consequences. So I think it really, what we're talking about really comes down to judges, because the judges are the ones who can control the lawyers, issue the sanctions. And I think maybe we should build a website like a rankyourjudge.com or something that where people can get on and describe, you know, objectively and factually what their judge did, so that when the voting time comes around, people have a place to go to decide who they want to vote for. Another thing is if someone finds himself on a jury, a med mal jury, or a harassment, a med mal case or a harassment case, they should stop and think twice about tort reform, its effect on their unconscious, you know, decision-making process, and really listen and be open-minded, because we're moving towards such an uncivilized society with people being so cruel and so hateful, and I think that needs to turn around.
You know, there's a old adage in law that you can't tamper with a jury, because once the jury is selected, you can't, you know, try to negatively influence them. But something that happens is, in a sense, jury tampering on a large, very large public kind of level, where the tort reform ideas, if we can paint every plaintiff as just a greedy person trying to abuse the system, if we can paint every plaintiff as a greedy lawyer, and if we can paint every defendant in a tort suit as a poor, overworked
victim of a
victim
frivolous lawsuit,
and a corporation that is a job creator and just trying to save money, like they're going to pass along.
They're programming the public, and they know these are not small companies; they're huge corporations. They know what they're doing. But we're running out of time, so let's wrap it up. Thank you so much for coming, Fred. It's been such a pleasure seeing you here, and thank you very much for tuning in to Meet the Professors. I'm DEANA Pollard Sachs, Professor of Law at Texas Southern University, and we hope to see you again.